Welcome to In the Courtroom and the Boardroom, Business, Law, and Litigation with Colleen McKnight.
Hey everybody, welcome to an all-new episode of In the Courtroom and the Boardroom, Business, Law, and Litigation with Colleen McKnight. I'm your host, Mike Leon. Colleen is the founder of McKnight Law PLLC and is a seasoned trial attorney with first chair experience in state, federal, and arbitration forums. And she helps business leaders protect what they've built through litigation when necessary and strategic counsel whenever possible. And in today's episode, we're talking about fraud and fiduciary duty claims. These cases, they strike at the heart of trust and leadership, and the outcome could actually reshape a company. Colleen, good to see you as always. Let's talk about what legally qualifies as fraud in a business dispute.
Yeah, Mike, thank you so much. I'm excited to get into this. So when we're talking about fraud, we're really talking about something that's dishonest, right? That's really kind of the heart of it. We're saying this is not just somebody's best judgment or their decision on which direction they wanted to go. There's some self-dealing. There's something happening behind the scenes that if you heard about it, you would think that's not right. And so courts are kind of tasked with, especially in business disputes, giving business judgment to business owners, right? They're not there to tell you how to run your business, but they are there to prevent you from doing things that are dishonest. Mm-hmm. And so fraud is often a carve out in contracts. It's a carve out in insurance. Unfortunately, it's not uncommon, but it is something that as business owners, you need to be careful that your team isn't doing, that you're not doing something that you think is allowed, but is actually going to be dishonest if it's looked at under the right light, and that you're being honest and forthright and fulfilling your duties to the people you have those to.
Well, let's talk about some of those duties. So explain how do fiduciary duties arise for partners or even officers, directors, and what do they actually require?
Yeah, that's a really great question. So a fiduciary duty is a really high duty. I remember having a professor in law school who would quote from a Supreme Court justice that a fiduciary duty is intense. It's incredible. It is the duty that you would expect that you would give to your children, that you would give to a brother, right? And so it's not a light standard. It is the idea that you would put them before yourself. Their interest comes first. So as an attorney, I have a fiduciary duty to my clients. I cannot decide what's best for me ahead of what's best for them. And the same is true for the directors of a corporation. They have to put the corporation before themselves, which means they're putting the shareholders before themselves. And usually the way that we see that play out is in two specific duties. That's the duty of care and the duty of loyalty. Those are the ones that we see come up when we're talking about breaches of fiduciary duty or fraud the most often. Oftentimes we'll see if I decide as the director of a company to contract with one of my other companies and give them a sweetheart deal, the courts will often look at that and say, look, that's a breach of the duty of loyalty. You have done some self-dealing here. You've given a better deal because it's you that you're contracting with than if it was a third party at arm's length. Or if I have decided to take some of the money off the top and move it into another fund that I'm using for my expense account, right? Maybe I think that that's fine. It's just where the money moves. But if the court looks at it and says, look, you're getting a benefit here at the expense of the shareholders, then that's going to be a breach of your duty to the company, and you haven't cared for it the way that you should as the person in charge.
Let me ask you, staying on that, what other red flags should business leaders, be aware of that, let's say, might indicate fraud or even misuse of authority?
Often you got to follow the money. Follow that money trail and find out where the money is going. And so you need to be, as a business owner, very aware of your numbers, how accounts are moving, how things are going. And you also need to be aware of your board, right? I've seen a case recently where a company was a distributor for a product and they were going to move into manufacturing that product as well as distributing it. Well, if they have a board member that's also a manufacturer, that's going to create a conflict of interest that's going to not allow that director to have that duty of loyalty, because they can't be loyal to a competitor, right? Like, that's common sense for us. And so you have to look at your board as you make business decisions. You have to follow the money to see, where is it going? Are we following standards for accounting? Or is there a place where somebody, maybe not even with bad intent, but is moving money in a way that creates some self-interest or self-dealing? We are people first. We in the US have given corporations personhood. They can be sued, they can sue, but they're all run by people. And people under stress will do crazy things. They'll make bad decisions. Sometimes they'll do things to get themselves out of trouble. That's a breach of the duty of the company. But I want to be clear that you, as a business owner, have judgment of how you run your business. And so oftentimes what we'll see in these disputes is the courts coming in and they're saying, which of this is a breach of fiduciary duty to run the company well? And what of this is your judgment as a business owner and a business leader that I'm not going to come in and second guess? And it's an interesting background story on that. It actually starts with Ford. So, in the 20s and the 30s, Henry Ford said, I want everyone to have Sundays off. I want all the workers to have this day off. I think this is what's best for the company. And the shareholders said, we want everyone grinding 7 days a week. That's what's going to get us the most profit. And so by giving all of these employees Sunday off, you have breached your duty to us. And Henry Ford went to the courts and he said, I'm the business leader. I should have the judgment to say what will ultimately make us the most profitable. And I can't have the courts coming in and second guessing that. And the courts agreed with him. And so the business judgment rule was born in that case that says there are these duties of care and loyalty. But apart from that, we're not going to step in and say you shouldn't have taken that loan under those outrageous terms. You shouldn't have hired that person at that rate. Even if ultimately, in hindsight, that harmed the business, that's not a breach of fiduciary duty. That's not your breach of duty of care or loyalty. You get to run the business and you get to be wrong sometimes. And so I don't want business owners hearing this to get very, very tense or worried that every decision they're going to make could be questioned as a breach of these duties or as fraud. You really have to be careful of self-dealing, conflicts of interest, things that would put your interest before the company, but you don't have to worry about everyday decisions.
Well, Colleen, staying on that, so let's talk to that business owner leader here. They suspect misconduct. The company suspects misconduct. What should that leader do right away in terms of protecting both assets, information, et cetera?
Yeah, absolutely. So I would put a hold order on all emails and all data, right? We don't want an automatic deletion to get rid of what could prove that there is misconduct or is not. So you want to kind of halt your retention policy, say we're not going to delete things, right? And then you want to go in with your accountant and chase that money, follow the trail, figure out what's happening, perhaps hire an investigator, someone who is neutral to the business. And then talk to a lawyer to make sure you're following the right steps, understanding with your specific circumstances, with what you suspect as potential misconduct here, what do you need to be looking into and where might you overstep? Because you don't want to accuse anyone of something before you have the evidence. But really kind of looking deep into your numbers, looking deep into your contracts, and understanding where people might have conflicts of interest is going to be your best course of action.
Yeah. Speaking of the courts, let me ask you, Colleen, how do the courts actually distinguish between, let's just say, an honest business mistake versus an actual breach of fiduciary duty?
Yeah, that's a really great question. And it's not always straightforward, right? Texas, where I practice primarily, has just codified that business judgment rule. So it's actually written down in the law. It's not just what we call common law, which is what the judges' opinions over time have established, right? And so the question for courts of, is this going to be a breach of fiduciary duty? or is this just them operating within their business judgment, is often going to be a pretty factually intense process. Who were you? What were you doing? What was the result of that contract? Did you have the authority, or did you reasonably believe that you had that authority? Right? Sometimes when you have a hostile takeover of the board, or you have turnover with your executives, where people have authority can get kind of muddy. And believing, okay, I thought I had the right to sign this contract, and I thought this is where we were going. This aligned with the strategic plan. Or I believed that taking out this loan, even at nearly usurious rates of interest, was the only way we were going to make this next shipment and not risk all of our goodwill and all of our, reputation. Sometimes those are things that you're doing in your best interest. Now, if getting that loan and paying that contract put money in your pocket and not necessarily the company's pocket, the courts are going to be a lot more suspicious of that. I mean, self-dealing is something that we see often. And so maybe my brother-in-law has the best vendor for this company, and he's going to give us the best rate. And it makes sense to do business with people you know and you like. But if in giving that deal to my brother-in-law, I'm getting some kind of kickback or some kind of benefit to me personally, not the company, I'm putting myself at risk, or the company at risk, of breaching those duties. And so, sometimes I make the reservation for my flight on my personal credit card so that I can get the points, right? Nobody really bats an eye at that. Nobody's offended, especially if there's not a company card that would be collecting those points. But if you extrapolate that situation and say, I'm doing things for the company that then also benefit me personally, and there was a way to pay the company back and I didn't, you're risking that breach of fiduciary duty. And the court is going to look at, how did you specifically benefit, or your immediate family members or close associates benefit? And how did the company benefit, to decide, Henry Ford wasn't making extra money when he gave everyone Sundays off. He wasn't deriving a personal benefit. And so it was easier for the courts in that situation to say, hey, shareholders, you're afraid your profits are going to go down, or your dividends, but he's not benefiting personally from that. And so we're not worried that this is a breach of duty or a fraud. He gets to run the business.
Colleen, what about the legal remedies for companies in some of these cases? What can they do in terms of seeking damages or even reversing transactions? Take us through that process.
Yes, and this is really one of the benefits of, and I say benefits, no one wants fraud committed against them, and no company wants a breach of fiduciary duty from their executives. But the law is really strict on these things and allows often for punitive damages. So we're not just going to make you whole by giving you back what you lost. We're also going to go in and actually punish them for this conduct by making them pay punitive damages. And those are really rare in the law, particularly on the civil side. Courts are pretty loath to say, hey, this was a business transaction, but I'm going to punish you for it. But breaches of fiduciary duty and fraud are two areas where we see that often. And sometimes we'll even see the damages get trebled, which means they'll triple. So if you lost $1 million because of my fiduciary duty breach, you could get up to $3 million as a punishment because it shouldn't have happened. This isn't how this was supposed to go. And so, companies thinking, hey, my board member has this conflict of interest and they're voting in a way that's harming our company because they're not being loyal to us, right? You have the option to say, you need to step down because you have this conflict of interest. And if you continue to vote in a way that harms us, we can bring these claims against you and get damages as well as punitive damages, right? It's tricky sometimes on the breach of fiduciary duty on the factual side. Can we prove self-dealing? Can we prove that you weren't acting within your business judgment? You weren't acting for the benefit of the company? If so, then how did it harm the company, right? If all those contracts were stopped in their tracks and we didn't actually let you move them forward, there might not be much damage that we can prove and collect on, right? If you went out and spoke poorly of the company and breached your confidentiality and spread rumors such that the company's reputation was potentially harmed, but the people you spoke to know us and like us, and they've continued to contract with us, and there hasn't really been a loss, you're going to have a harder time going to court and saying, you need to make him pay me for the loss of goodwill when I can't prove we actually lost it. Now, that's not much comfort to a business owner who's being maligned in the marketplace. It's not much comfort when you say, I don't know who would have contracted with me but for this breach of the duty of care and loyalty. And so oftentimes you see companies kind of settle these claims or limp along and try and just mediate and remediate what was done rather than bring them as claims. But often it's worth going after them to say, you've caused us this harm, even if it's just setting the record straight in the public filings, right? Even if it's just telling your story in your court documents to say, this person hasn't been honest with you or the public or what has happened. And I need to set the record straight in the pleadings, even if ultimately I'm not going to get a huge amount of damages on the back end.
Colleen, let me ask you then, are fraud or fiduciary claims usually handled as civil litigation, or does it fall sometimes into the criminal side of this?
That's a really great question. It's really rare that a fiduciary duty claim would be criminal, right? It's a duty that the civil law has imposed to say, if you're going to run this business, then you're going to be a fiduciary. That being said, as a lawyer, if I breach my fiduciary duty to my clients, there is a chance I could cross into criminal territory if a client of mine has, let's say, HIV, and I got that through attorney-client communications. I know it, but I reveal that in the public space in a way that harms them. That could be criminal defamation or criminal slander, something that would harm them on the back end. Fraud, on the other hand, is often also a criminal case, right? And at a large enough scope, you'll see Bernie Madoff, you see these Ponzi schemes, these kind of frauds, or when Volkswagen knew that its cars were not meeting the standard for emissions, but it lied about it and the cars went out into the world and broke that standard. That there were civil claims with respect to that as well as criminal action, because that dishonesty crossed both lines. And sometimes those cases will proceed parallel at the same time. You'll have the AUSA or a district attorney bringing those fraud claims at the same time that the people who were harmed are bringing it as a civil action. Oftentimes, the reason you want a civil claim in addition to the criminal claim is that restitution, right? Lock them away for what they did on the criminal side. That's great, but that doesn't make me whole. I don't get back the money I lost or get my business back on its feet just because you went to jail. And so you'll see those parallel claims come with fraud more often.
Colleen, then let me ask you, as we land the plane on this episode, what advice would you give to an executive or a founder out there? They're listening to this. They want to minimize the risk of facing potentially fraud or fiduciary duty litigation to begin with. What's a piece of advice you would give to them?
Yeah, I think you need to keep your records in order. You need to know how your accounting works and understand the stories that your numbers are telling. And you need to have a good filing system and understand when things get deleted and when they don't, right? When I say follow the money, when it comes to fraud and fiduciary duty, that is going to be your best answer. And oftentimes, I know as a business owner, keeping track of the numbers is 16th on my list. Making sure my filing system isn't a disaster isn't the most urgent task that I have today, but it's those backstops in your back office that are going to be able to give you peace and make any potential tortfeasor, somebody who wants to hurt you, know this is going to be harder because they know what's going on. They have somebody checking behind. I can't just take this money and use it for my own benefit. They're going to find out. And so often this ounce of prevention is worth a pound of the cure. And it's a heavy burden as a business owner, but it's not one you can't carry to protect yourself from this kind of liability.
Follow the money, as in all walks of life. Colleen, thank you. Colleen, thank you so much for the time and insights. We truly appreciate it.
Yeah, thank you.
And thank you to everybody out there for listening to today's episode of In the Courtroom and the Boardroom with Colleen McKnight. Look, fraud and fiduciary duty claims can turn trusted relationships into courtroom battles, but the right strategy can protect both your business and your future. And if you're a business leader out there, you're facing these issues and you want to reduce the risk of them even happening, do me a favor, visit McKnightLaw.us today to connect with Colleen and the team. Don't forget to like, subscribe, leave a review and comment, or share this episode with someone who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.